Hello po, hello po. Magandang hapon po sa ating lahat. Magmask muna ako ngayon ha, kasi palagi akong nakalanghap ng malamig na hangin kaya hindi magkatanggal-tanggal itong ubo ko. Mm-mm. Magandang hapon po sa ating lahat. Ito po ang inyong lingkod, si Pelcor Ellen. Live po tayo ngayon. Maaga tayo ngayon mga kapatid ko kasi holiday ngayon dito sa kanila. Kaya walang labasan, nasa bahay lang. Pero marami man akong ubosipon ngayon. Oy, hindi naman ito grabe naman. Kaya maayong hapon din po, Ma'am Alma. Salamat po, maaga. First honor si Ma'am Alma. Okay. Alright, so pag-usapan natin dito mga kapatid ko, itong patungkol sa ICC. Unsay nasabtan natin sa confirmation hearing sa ICC noong nakaraang final. Itong final days na lang ang batayan natin. Itong panghuling araw. Last Friday, mga kapatid ko. Okay, pasok na po kayo, pasok. Pag-usapan na po natin, sorry kahapon wala tayong live. Kasi grabe talaga ang ubusipon ko, grabe. Hanggang ngayon, kakainom ko lang ng gamot, tapos magmas lang muna tayo kasi parang nasuhot man siya sa palagi kong nakalanghap ng malamig na hangin. Kaya, sige, magmas lang muna tayo. Consideration sa weather condition. Okay. So, mga kapatid ko, patuloy tayo. Anong nasabtan natin? Anong naintindihan natin sa confirmation of charges of Duterte's hearing in The Hague? Alright, paghimay-himayin natin dito. At bago ang lahat mga kapatid ko, I would like to introduce to you first. Okay, alam na ninyo na ito si Attorney Nicholas Kaufman ang legal counsel ni Pangulong Duterte. At saka ito si Jewel Butuyan, ang legal counsel ng mga biktima. Okay? So, at ito ang tatlong judges na mag-decide sa kaso ni Pangulong Duterte kung anong pinagsasabi sa dalawang abogado, sila ang magdesisyon. Okay. Ito si Judge Rini Adelaide Sophie sa Alafin Ganso. Parang saan nga lugar itong ganito. At si presiding judge Julia Antoniela Motok. Kung ano ito, Romanian. Ito parang South American ito. At ito si Judge Maria del Socorro Flores Lira. Ito siya is Mexican. Okay, Mexico. Hindi tayo magkalayo sa Mexico, mga kapatid ko. Ang mga drug cartel diyan ay marami din. At ang mga Mexico ay magkatulad lang sa atin, mga Catholic faith din yan sila, Defender Christians. At saka, hindi tayo magkakalayo sa kanya. Sana naman, walang bias ang desisyon nila. Yun lang ang hinihintay natin. Yung bang desisyon na fair ang nila. Okay? So, dito mga kapatid ko, nakikita natin ito si Attorney Butuyan nga nagpresenta siya sa kanyang argumento patungkol sa krimen nga nangyari sa kay Pangulong Rodrigo Roa Duterte. Pero sa tingin ko mga kapatid ko, hindi din siya selective lang din siya. Yung bang mga videos, mga clippings na videos, mga video clip, ay pinuputol lang nila, pinipick up lang nila ang statement ni Pangulong Duterte. Tapos, yun na ang ginawa nilang evidence. Mhm. Ibig kong sabihin, example, yung video na nagsabi si Pangulong Duterte sa press conference niya sa mga kapulisan, that if you just do your work and you can have the wavering support of the office of the president. But if you work, what is that? Beyond the law, there's a hell for you to pay. Ganun ang pagkakasabi ni Pangulong Duterte. Ang pinick up lang nila, yun lang wavering support from the office of the president. Tapos, ibig kong sabihin, yung mga video clips din nila, pinuputol nila. Tapos, yung mga talumpati, parang si Atty. Butuyan, ay nagsasalita lang patungkol sa pangyayari sa ating bansa na may krimen talagang nangyari. Pero hindi din niya binibigay ang mga evidences. So, lahat lang parang nagsasalita lang siya. Kaya may mga video tayong nakikita na underestimate siya ni Trillanes. Pagiging counsel niya na mahina daw abogado. Si Trillanes naman, siya na ba hindi mahinang sundalo? Sundalo lang siya sa mga kanin. Yon. Kaya, kung hindi lang magiging bias itong tatlong judges na ito, ay sigurado magdesisyon sila patungkol dito, fair and clear, talagang mananalo si Pangulong Duterte. Pero pag bias itong tatlong judges na ito, ay siguradong delikado matalo si Pangulong Duterte. Pero alam naman natin na mayroong speculation na may bayad daw ito sila. Hindi natin masyadong alam yan. Pero may bayad daw di umano itong mga judges na nagpunta sa Philippines noong 2023, 24, 25 ba yun? Kaya hindi pa natin yan masasabing manalo si Pangulong Duterte, hindi pa rin natin masasabing natalo. Tingnan natin kasi within 60 days, mag-decide na itong tatlong judges na ito. Okay? So, ang presiding judge nila ay si Judge Motok. Okay? So, tingnan natin kasi maganda ang pagpresenta ni Atty. Kaufman patungkol sa kaso ni Pangulong Rodrigo Roa Duterte. At magaling talaga siya. Yung mga statement ni Butuyan ay na-pick up talaga ni Atty. Kaufman bago siya magpunta sa sarili niyang statement na dapat niyang sabihin, pinag-strike muna niya ang pagsasalita ni Atty. Butuyan patungkol dito sa mga statement na sinapchap, putol-putol na mga video clips na pinagsasabi nila. Okay? So, at mayroon din silang video na para bang kay James Bond na License to Kill at saka yung double barrel, ganun. So, yun ang nakikita natin, mga kapatid ko. Alright, so pakinggan natin kung paano nagdepensa si Atty. Kaufman doon sa daheg. Okay? So, ito ang si Atty. Butuyan, nagpresenta siya sa argumento niya doon sa pre-trial chamber sa daheg confirmation hearing. At si Atty. Kaufman din in behalf of Pangulong Duterte. He is a legal counsel. So, pakinggan natin si Atty. Kaufman at mag-reaction lang tayo dito. Ay, sandali lang.
Consideration. And we did in fact have a short version prepared and a long version prepared. So I'll be reading from the long version, and that was specifically so that we could accommodate the redactions that have been so insisted upon, and we respect that, of course, by the prosecution. So I now turn, with respect, Your Honours, to count 2. And this concerns the alleged murders of high-value targets during the presidential period. And before addressing the individual incidents that the prosecution characterises as involving so-called high-value targets, the defence makes a preliminary observation. The term high-value target appears throughout the prosecution's brief as though it is evidence of a coordinated plan to eliminate targets. With respect, that inference cannot be sustained. The existence of a prioritisation category within a law enforcement campaign does not establish a criminal plan. HVT was an operational classification used by law enforcement, and in this sense it is no different from a similar acronym in another country where I have clients. APOTS, or Australian Priority Organisation Targets. HVT is not a code for an instruction to kill or a witch hunt. It was a prioritisation tool within anti-drug operations applied across regions and units on the basis of intelligence assessments, alleged position within drug networks, or inclusion on watch lists. Classification does not imply selection for murder, any more than it is proof of unlawful intent. The prosecution itself acknowledges the existence of formal operational frameworks, including police circulars and structured campaigns. Within those structures, individuals could be designated high value for purposes of operational attention. Many HVT operations, in fact, resulted in arrest or surrender, albeit some resulted in fatal encounters. For this reason, each alleged HVT incident must be scrutinized on its own evidentiary foundation.
정말 부탁드립니다. 제발 저희를 도와주세요. 저희 공방은 지금 생존이 걸린 위기 상황에 놓여 있습니다.
When the incidents falling under count 2 are examined individually, the pattern we submit is similar to those incidents falling under count 1.
Okay.
Namely, heavy reliance on insider testimony, wishful and selective reading of police reports, and dubious and tenuous linkage to Rodrigo Duterte. Now, the operations cited under count 2 were conducted within the framework of the lawful war on drugs, and as such, operational contexts are consistent with planned law enforcement activity, including buy-bust operations and coordinated arrests, rather than preordained killings. The evidence for count 2 incidents consistently shows that the deaths occurred during armed confrontations in which force was used in response to an imminent threat, in accordance with the rules of engagement repeatedly articulated by President Duterte, namely that lethal force was permissible only where life was in danger.
Okay,
Across
so,
the count 2 incidents,
yan. That is the statement of Pangulong Duterte. Little force is only necessary when your life, when the policeman, he's talking about the policeman, when your life is in danger. Okay. Right. So, dito. Pero kinakat nila ito.
There exist contemporaneous documents, whether it be arrest warrants, operational records, or firearms recovery reports, all of which reflect legitimate police operations that escalated into exchanges of gunfire. The general record does not substantiate a theory of wanton execution, yet the prosecution seeks to rely, once again, on the testimony of criminals spilling their hearts with a tacit understanding that they will never be prosecuted. In 4 of the 5 incidents, contemporaneous reports document the recovery of firearms at the scene, indicating that the weapons were used against police and prompting a responsive use of force. In incidents 12, 13, and 14, the operations were authorized by judicially issued search warrants. We have diagrams on the screen being shown. I'm not going to stop. They will be presented throughout my presentation continuously, all in an attempt to save time. Those circumstances are squarely within operational legality and fundamentally incompatible with a pre-planned murder. Incident 14 is particularly instructive. 4 individuals were arrested alive. To us, that demonstrates selective and not indiscriminate use of force. In incidents 10, 13, and 14, gunpowder residue was detected on the victim's hands. At a minimum, that forensic finding is consistent with an exchange of gunfire and not consistent with a straightforward execution narrative.
Okay, good.
And the prosecution and the victim's representatives simply can't have their cake and eat it. They can't say in one breath that drugs and guns were planted on victims and therefore dispute crime scene evidence, while at the same time complaining about the lack of crime scene evidence. Yet the prosecution virtually disregards these objective and forensic indicators in favor of narrow and often uncorroborated insider testimony. This is best illustrated in Incident 10, which rests almost entirely on P1160's assertion that a firearm was planted at the scene of the crime, and the official report fabricated. Yet P1160 expressly accepts that he did not witness the planting of the firearm and merely assumes that it must have happened, before conceding that the firearm may already have been present. Once again, we are in the realm of inadmissible conjecture. We know that an investigation followed that incident. The opening of an inquiry is not consistent with the intention to conceal wrongdoing. Beyond that, as I've just mentioned, the record reflects the detection of gunpowder residue on victims' hands in this particular incident, a forensic indicator consistent with an exchange of gunfire and inconsistent with the witness's testimony, which is notably, once again, uncorroborated.
우리 집 거실에는 먼지가 전혀 없습니다. 제가 특별히 부지런한 것도 아니고 좋은 도구를 가지고 있기 때문입니다.
Incident 11. This is the sole incident in count 2 where direct linkage to Mr. Duterte is advanced. And this linkage rests entirely on voice recognition by an individual who claims to have overheard a telephone conversation and recognized the president's voice while being physically moved from one location to another. The alleged recipient of the telephone call himself was never interviewed, and another person present on whom the prosecution relies for corroboration did not hear the conversation. After all, would it not have been an item of interest to all those present in that specific location that the President of the Republic himself had condescended to discuss matters of such a criminal nature by way of telephone. So the ridiculous assertion stands solely on the word of one single individual. The only other corroborating witness, the one who heard nothing, acknowledged a personal resentment that he harbored for the then president, Rodrigo Duterte, for reasons you will find in PHL OTP 000164220-R01 at 0022 lines 695 to 708. Once again, I can't mention the reasons because it's redacted.
Yan. Okay. So dito mga kapatid ko, may conversation sa telephone that they cannot mention it because that is a reduction. Mayroon siyang reservation. Once again, I cannot mention the reason because it is redacted. Redacted is you cannot mention it because of another reason. Okay? So that is it. So that is the fourth person is talking about. Alright, the send of Duterte to the head. Okay.
Voice recognition in uncontrolled conditions while being physically moved, and uncorroborated by any forensic or documentary evidence cannot constitute substantial grounds for confirmation, particularly where it forms the sole mechanism for attribution. Incident 12. This incident relies heavily on a central witness whose credibility is seriously compromised by retaliatory motives he admits to harboring against Mr. Duterte. This can be found in OTP tab 55 at page 27. Line and another reason that we cannot mention in open session, but which can be found in PHL OTP 000-15167-R01 at page 0008. For this particular incident, the case record demonstrates that this operation was conducted pursuant to a judicially issued search warrant, with operational reports and documentation concerning the recovery of firearms. To display such an extensive contemporaneous record, one would expect the prosecution to produce forensic evidence capable of undermining the reliability of these materials, evidence demonstrating fabrication or inconsistency sufficient to reduce their probative value. None, however, has been forwarded, because none presumably exists. Incident 13. This relates to the killing of Mayor Espinosa, whose name I can mention, and Raul Yap, who was shot in a police cell. The prosecution's case is largely premised on a witness who claimed to have heard but admitted not to have seen anything. Thus, there is nothing in the prosecution's evidence to contradict the alternative theory proposed for this incident, which is that there was a firefight between the victims and the officers in the police station Leyte sub-provincial jail. Nor is there a need to enter into these conflicting accounts because the prosecution's own evidence exculpates Rodrigo Duterte for responsibility for this incident. Not that he admits any connection to it. After all, according to the prosecution, on 1 August 2016, Rodrigo Duterte gave Espinosa a 24-hour ultimatum to surrender. And surrender he did the following day. 4 days later, Rodrigo Duterte commended Espinosa for surrendering to Ronald de la Rosa, commenting that it was just as well that he did. So if we look at it from the point of view of Rodrigo Duterte, that is where the incident ended, despite Mr. Jeremy exhorting us to believe otherwise. What happened thereafter, as awful as it may be, had nothing to do with our client, and not one witness can say that.
That's it. Very good, mga kapatid ko. Remember, yung kay Mayor Espinosa, nasa cell siya pinusil, ha? It is not the Duterte has no connection for that incident. It is probably mayroong policeman na binayaran or probably may mga policemen na binayaran sa mga kalaban ni Pangulong Duterte kaya nangyari yan. Okay? So, hindi natin pwedeng ihambing lahat. Hindi natin pwedeng ihambing lahat kay Pangulong Duterte itong mga pangyayari dito, mga kapatid ko. Alright, tuloy tayo.
The prosecution's narrative in Incident 14, the raid on the house of another person who I can mention, the mayor of Ozmiz City, rests exclusively on a witness who, for reasons we cannot explain in open session, is wholly unable to provide complete or reliable testimony for reasons that can be found in D36, tab 181, lines 128 to 155, and lines 191 to 212. Contemporaneous documentary police reports reflect that this police operation proceeded pursuant to 6 judicial search warrants, something hardly consistent with a premeditated murder scheme. After all, if the intention was cold-blooded murder, why go to the bother of involving a judge? Official investigative materials also indicate that officers approached the premises, announced the execution of the warrant, and were met with gunfire that struck a patrol vehicle and injured an officer, prompting a return of fire. This directly refutes what Ms. Masita so categorically claimed on Tuesday, namely that none of the arresting officers were ever harmed during the operations. Transcript. T5, page 44, line 24. In every case, the victim was killed, and none of the arresting officers were harmed. The exchange of fire, as reported, is supported by the fact that gunpowder residue was found on 7 individuals, including on the mayor himself, and a paraffin test turned out positive on the person of one of the victims, indicating that he had discharged a firearm, something totally negating the gun plant theory proposed by the prosecution's only witness. It is also worth stressing that 4 individuals were arrested alive following the operation, and that one of them was subsequently sentenced to life imprisonment after the domestic courts rejected claims of evidence planting. That fact alone is not consistent with a theory of indiscriminate execution, but is rather consistent instead with arrest and prosecution within the boundaries of the law and not indiscriminate use of force. So to summarize, across incidents 10 to 14, count 2, we see absolutely no evidence whatsoever of any attribution to Mr. Duterte on the granular level, nor do we see any evidence of a mutually agreed course of conduct on the upper hierarchical level of government involving Mr. Duterte and his alleged so-called co-perpetrators. The record reflects police operations conducted at unit level, sometimes under judicial warrant. P1166 describes operational discretion resting with the local team leaders and characterizes planned killings as rare and locally motivated. P1066 clarifies that to neutralize, that word which has been heard so often in the last few days, neutralize referred to lawful enforcement, not killing.
Yes. So dito, ang gusto nilang ipapalabas sa ICC nga si Duterte nag-order to neutralize the criminals, the drug lords, the drug pusher. No, it's not. It is a lawful order to capture the drug addicts, not killing them. Tama si Attorney Kaufman dito. Okay, yan ang gustong ipinapalabas. Iyon ang gustong mangyari ni Pangulong Duterte. Hindi kay neutralize, kill them all. No, not that way. Okay? So mga kapatid ko, bago tayo magpatuloy, mag-like naman kayo at mag-share dyan. Okay? Tuloy tayo.
Killing, the prosecution's own witness. The Senate committee report refers to rogue uniformed police. To conclude, the evidence reflects decentralization, not control required under indirect co-perpetration. And for these reasons, confirmation on count 2 cannot stand. Now, I'm going to start count 3. We have until 10:30. I'm conscious of the time allotted to me. So count 3 relates to the barangay clearance operations during the presidential period. Incident 15 marks the beginning of the barangay clearance operations.
Pasok na po kayo, pasok mga kapatid ko, kasi this is very important. Hindi tayo pwedeng magdiretso sa conclusion, decision ng mga judges. Kailangan malalaman din natin ang mga arguments ni Atty. Kaufman at ni Atty. Butuyan. Kasi parang malaman natin kung mayroong bias ang decision sa mga judges, mga kapatid ko. Okay, tuloy.
Now, from this point forward, a familiar pattern emerges in the prosecution's narrative. The same modus operandi, to employ Mr. Jeremy's language, routine buy-bust operations are recast as sham exercises designed to conceal extrajudicial killings allegedly ordered from some unspecified source from above. Mr. Jeremy claims a target was identified through the use of lists. Well, there's nothing wrong with that. As one witness, an intelligence officer, explains in his testimony, the use of lists is a normal standard procedure. Once validation was conducted on a person, X, a file on that person would be created as a result of intelligence operations. Then, so claim Mr. Jeremy and Ms. Croft, the target is murdered and reports are falsified and rewards are paid out. This, Ms. Croft suggested at transcript 5, page 23, lines 11 to 13, is the systemicity of the pre-planned attack. But this is not the case. The defense can point to contemporaneous official records generated across different units or organizations that show clearly that in the majority of these incidents, the evidence reflects legitimate law enforcement operations involving spontaneous and reported exchanges of fire and uses of force subjected to forensic and administrative review. These are not clandestine acts hidden from scrutiny, Madam President, but rather recorded operations consistent with self-defense in the course of policing. And where the evidentiary record supports competing inferences, including the inference of a lawful armed confrontation and the inference of an unlawful execution, well, and with this I will conclude, in dubio pro reo. 10:30.
Merci beaucoup.
Thank you very much, Mr. Kaufman. So I've understood that you would like to use the time that remains to you, and you have you still have 20 minutes actually. I understood that you wanted to use that time. Yes, I would, but I'm not so sure if I can conclude in 20 minutes.
C'est possible. OK. Nous essaierons, Madame.
Ouais, donc vous avez la...
Judge Motek, very well. It's still you. You have the floor. Proceed.
Thank you.
Across incidents 15 through 49, the Chamber will repeatedly encounter contemporaneous buy-bust or warrant-based documentation, reported exchanges of fire, gunshot residue findings, ballistic testing, immediate hospital transport, internal investigations, and in some cases, prosecution and conviction of officers. Against all of this evidence that you've just seen on the screen here, the prosecution offers single insider accounts of alleged stagings, uncorroborated assertions of weapons planting and nanlabans, unsupported by any forensic evidence, often speculative, frequently contradicted by the alleged co-participants, or yet, more often, complete silence from the alleged co-participants, as they were never even questioned about the incident. And most importantly, despite Mr. Jeremy's assertions on Tuesday, wherein he claimed that the police reports were repeatedly falsified to legitimate the operations as acts of self-defense, copy-paste reports in which victims were frequently blamed for their own deaths, there is zero proof,
Yan.
none, that the only existing contemporaneous documentary evidence is fabricated or unreliable. No proof whatsoever of this supposed falsification in the entire case record. And on this point, let us just clarify a basic principle, that a state document with the appropriate stamps and signatures and what have you is prima facie reliable, or in other words, it carries a presumption of administrative regularity. And if the prosecution seeks to displace that document and call the entire state apparatus into question, then the burden rests on it to produce credible, objective evidence rebutting that presumption. Bare allegations or reliance on single prosecution witnesses cannot suffice to overcome this presumption of authenticity and correctness, nor should the burden shift to the defense to prove that those documents are not falsified. Now, we do not deny that in some instances the record may reveal unlawful conduct by individual officers. Mr. Jeremy referred to a press release, OTP tab 108, in which the police proclaimed that 32 people were killed in Bulacan big-time operations, and then went on to refer to this as one single operation in which 32 victims were killed by the police in Bulacan. But what Mr. Jeremy failed to tell you, Your Honours, is that one of the prosecution's own witnesses explained clearly that he investigated these deaths in an official capacity soon after the killings and found that 33 people were actually killed in different municipalities and provinces in central Luzon,
Okay.
but that their bodies were delivered to Bulacan.
Oh my God.
This was not, as Mr. Jeremy suggested, a single incident of mass murder, but rather an improper aggregate of a series of law enforcement operations over the course of 24 hours executed in large geographical area and for which we have no evidence in the case record. There's no evidence on the perpetrators, victims, motives, manner of attacks, methodology, in essence, nothing to link them to an alleged fantasy common plan. Everything is just stitched together enough to give it a veneer of organization. I now turn to incidents reflecting documented armed confrontations. And as mentioned when I first turned to this count, the documentary record, which has not been displaced by any evidence proffered by the prosecution, reflects attempted arrests, resistance, and responsive use of force. And you've just seen some of the documents up there on the screen. Let's turn briefly to Incident 17, for which the prosecution has relied on a witness who stated that the planting of evidence was an open secret in the locality and province more generally. However, another witness working in the same locality, P1208, states otherwise, that he was never involved in illegal operations resulting in deaths, was not aware of extrajudicial killings disguised as lawful operations, and confirms that there were no standing orders to kill. The operational objective, he explains, was arrest. Lethal force only when the circumstances required it. And you can find this information in Defense tab 96.
이제 출퇴근용 가방, 주말용 캐주얼백, 출장용 여행 가방 따로 살 필요 없습니다. 이 한 가지면 모든 상황이 해결.
Okay mga kapatid ko, just a moment. May message si Ma'am Alma dito. Sa panahon ni President Duterte, nag-decrease ang mga addict at mga pusher. At maraming nag-surrender sa tukhang. Maraming na-rehab at bumalik ang magandang pangatawan na paglabas sa rehabilitation center. Tama ka dyan, Ma'am Alma. That's the truth. Pero iba ang pinalabas dito ni Butuyan sa ICC. Okay. So patuloy natin pakinggan si Atty. Kaufman sa pagdepensa niya kay Pangulong Duterte. Okay.
We see this pattern again and again and again. In Incident 40, for example, P1131, who worked with the individual alleged to have shot the suspect, stated clearly that the killings occurred only in circumstances of lawful use of self-defense. That can be found at Defense tab 74, and you can see it on the screen as well. This type of testimonial evidence is also corroborated by documentary and forensic evidence.
Yan.
Incident 15, the prosecution again resorts to its usual pro forma narrative of stage killings or nanlabans. But what it has not done, of course, is prove this. Whereas I urge your honours to look at the screen where you can see detailed documentary evidence about how this incident came about, and I summarise: a spontaneous exchange of fire after the suspect discharged a firearm, ballistics testing of the officer's weapon, affidavits by the police officers involved, and formal review and investigation of the officer who fired his weapon. Now, I'm not going to sit here and bore you with all the evidence we have on every single one of these incidents, but what I will tell you, Your Honours, is that we have this type of forensic evidence proving attempts, arrests, armed resistance, and responsive and sometimes disciplined use of force in no less than 13 incidents. I don't know where Mr. Butuyan got the idea from that there's no forensic evidence left in the case record.
Okay.
And may we remind you, Your Honours, until the prosecution proves otherwise, which it has not, these state documents remain prima facie, authentic and reliable.
Yan.
For incidents substantiated by a single witness narrative and unconfirmed by alleged co-participants, I refer Your Honours to no less than 9 incidents. One prosecution witness, P1160, is the sole testimonial evidence for at least 3 incidents, while another 6 incidents are premised entirely on the testimony of P3. Now, what's interesting about these incidents is that P3 alleged that he was only one of a group of 3 or 4 perpetrators, and these other perpetrators are actually also prosecution witnesses. Yet none of the other witnesses corroborated his version of events. Not one. A couple of incidents alleged by the prosecution appear on its own evidence to be unrelated to drug enforcement and thus questionably part of the fantasy common plan or organizational policy. For this, I would refer you to incidents 31 and 41, which involved targeting of 2 individuals, again, because of non-drugs related conduct. I'm not sure whether I can mention the type of conduct without revealing the identity, so I shall refrain from doing so. The prosecution has not presented any evidence to substantiate any nexus to anti-drug operations in either of these incidents. And for this, I refer you to D36, tab 158, at page 4. On the perpetrator's own account, the trigger for the killing was a personal grievance relating to property damage. There are numerous incidents against unidentified or improperly identified victims. The victim in incident 45 is described as a minor, just as in incident 38, another incident on which Mr. Jeremy focused on Tuesday. And, by the way, on the subject of the killing of children, of course it ticks the right boxes for the prosecution insofar as it pulls the heartstrings. But apart from Kian de los Santos, the prosecution has not, despite its emphasis on children, presented to this chamber during these proceedings any evidence that even one victim, apart from Kian, in its 49 incidents was a minor. No birth certificates, no corroborative evidence, nothing. While incidents presented as involving minors are indeed grave, Article 61 requires proof, not emotion. It is for the prosecution to prove that the children were involved in these incidents, and not for the defence, once again, to prove a negative. Now, this evidentiary deficit extends even further. The Bulacan Provincial Office provided a certificate indicating that it had no record corresponding to the names of the victims, whose names have been redacted on the slide, which we will show you. Okay, but we'll pass on. But their names have been redacted. And these are alleged police killings, yet no operational report. Indeed, no contemporaneous documentation whatsoever has been produced. So on what does the prosecution base its claim that these individuals were murdered by the police other than P3? The prosecution relies almost exclusively on the account of P3 echoed by P8. And this is rather ironic. Does the prosecutor claim that P3 is corroborated by P8 when the source of P8's information is in fact P3 himself? Bootstrapping logic, once again. The alleged direct perpetrator, P1201, stated during his interview that he had never participated in an operation involving a child. The other officer allegedly present during both incidents, P1131, was never questioned about these events by the prosecution. And that admission, we submit, is not neutral. These incidents, therefore, cannot simultaneously be characterized as manifestations of a centrally designed OTBT-based common plan, because they quite clearly fall outside of that plan. And it does not reflect what the prosecution on Tuesday described as the systematic features of a national network operation. Instead, according to P3, the motive was personal financial gain through the sale of bodies. And if P3's account is accepted, it reflects opportunistic actions for personal gain of the most macabre kind. As held in Al-Hassan, an opportunistic act committed for personal profit without more falls outside the common plan. Now, just to finish up quickly on the issue of identity, in incident 43, even the alleged perpetrators are not identified. Without identification, the Chamber cannot assess their institutional affiliation, chain of command, or attempt to make any possible linkage to Mr. Duterte. One more thing, Your Honours. The prosecution focused for some time on incident 23. I can mention his name, Mr. Benjamin Vizda. Mr. Jeremy displayed compelling footage of Mr. Vizda's arrest and then what happened when Mr. Vizda was taken away on the motorcycle. The fact that while handcuffed, he attempted to grab the gun of one of the policemen, leading to a struggle and prompting the motorbike to fall over and the policeman to shoot Mr. Visda twice in self-defence. And that this PNP report appears to be corroborated by another prosecution witness, whose testimony fully aligns with the substance of the police document. Mr. Jeremy claimed that the PNP reports were false, relying solely on the allegation of one witness that the scene was staged. This witness claimed that the handcuffs were removed from the victim, that the body was loaded on the tricycle a few minutes after being shot and then brought to the hospital. However, his account is contradicted by the very picture the prosecution has shown you on Tuesday. Indeed, it appears that the prosecution is submitting documentary evidence which undermines its own witness's testimony. As you can see here, handcuffs are on. The body is on the ground rather than on a tricycle. Photojournalists are also present. This contradiction was even noted by the prosecution's investigators at the time of the interview and was put to the witness. And when confronted by the investigators, what did that witness say? I don't know if I can.
Nawala.
자, 밸런스 게임. 비싼 호텔 vs.
Okay, mga kapatid ko, mag-like and share naman
아고다
kayo
할인
dyan.
못해.
당연히 아고다 못해.
Like
남은
lang
돈으로
tayo
야식
po. And mag-share
prosecution
naman
must-
tayo po. Okay? So, sa mga bagong pumasok dito, mag-subscribe na rin kayo po. Okay? So, tuloy po tayo para mapakinggan.
Still establish vertical linkage to Mr. Duterte? Or has the prosecution 2 minutes left, not be satisfied? And finally, with regard to count 3, the prosecution's witnesses themselves concede that there was no formal approval process. Targets were selected without validation, officers acted for personal reasons, and decisions were taken locally. All of this destroys the assertion that there was a mutually agreed common plan. I will elaborate. P1160 claims hierarchical transmission of policy within the police, while simultaneously acknowledging officers' autonomous killings for personal motives. Those propositions cannot comfortably coexist. P3 explains that certain officers acted outside any common plan and for opportunistic reasons. See Incident 38. In Incident 49, P1207 attributes instructions to local officers without evidence of communication or direction from higher authorities. And most significantly, P1207 P1207 states after a certain death, once again abiding by the redactions, Tokhang operations and killings ceased. This indicates, Madam President, Your Honours, that dependence on specific individuals, not an enduring organisational policy. A system-wide common plan cannot depend on the continued presence of a non-fungible local official. And with this, I conclude.
Judge Murdoch, thank you very much, Mr. Kaufman. All the arguments on the merits have been heard. We will now break for 40 minutes.
Okay, mga kapatid ko. Dito lang tayo magtatapos, mga kapatid ko. Okay? Mag-break sila ng 40 minutes. Ang break nila, mga kapatid ko, 40 minutes. Sa atin, ang break is 10 minutes. Okay? So, tingnan natin dito. Makakatuwa itong break nila dito. Okay, so, mga kapatid ko, okay, sandali lang. Okay. So, dito tayo, mga kapatid ko. Kukuha tayo dito.
Please be seated. Veuillez vous asseoir.
Yan. This is the final na mga kapatid ko. Ito na ang final episode ni Kaufman na nagpresenta dito. Ipagpatuloy natin dito mga kapatid ko. Okay? Alright. Okay, so patuloy tayo mga kapatid ko. Dito natin mapakinggan ang fourth day na pagdepensa ni Atty. Kaufman dito sa kaso ni Pangulong Duterte. Magpatuloy tayo.
Judge Motok. Good morning, everyone. Kaufman.
언니 팬이에요. 너무 멋져.
Please go ahead.
I do indeed thank Your Honours for that consideration. And we did, in fact, have a short version prepared and a long version prepared. So I'll be reading from the long version, and that was specifically so that we could accommodate.
Just a moment please mga kapatid ko, ha? Sandali lang. Tatayo muna ako. Okay mga kapatid ko, this is the fourth, just happened this interrogation with Atty. Kaufman on February 27. This is Friday mga kapatid ko. Dito natin makikita ang final arguments ni Atty. Kaufman patungkol dito sa argument ni Atty. Butuyan, kung paano, tingnan natin kung paano niya ang laban.
Redactions that have been so insisted upon, and we respect that, of course, by the prosecution. So I now turn, with respect, Your Honours, to count 2. And this concerns the alleged murders of high-value targets during the presidential period. And before addressing the individual incidents that the prosecution characterises as involving so-called high-value targets, the defence makes a preliminary observation. The term high-value target appears throughout the prosecution's brief as though it is evidence of a coordinated plan to eliminate targets. With respect, that inference cannot be sustained. The existence of a prioritisation category within a law enforcement campaign does not establish a criminal plan. HVT was an operational classification used by law enforcement. And in this sense, it is no different from a similar acronym in another country where I have clients. A firearm was planted at the scene of the crime, and the official report fabricated. Yet P1160 expressly accepts that he did not witness the planting of the firearm and merely assumes that it must have happened, before conceding that the firearm may already have been present. Once again, we are in the realm of inadmissible conjecture. We know that an investigation followed that incident. The opening of an inquiry is not consistent with the intention to conceal wrongdoing. Beyond that, as I've just mentioned, the record reflects the detection of gunpowder residue on victims' hands in this particular incident. A forensic indicator consistent with an exchange of gunfire and inconsistent with the witness's testimony, which is notably, once again, uncorroborated. Incident 11. This is the sole incident in count 2 where direct linkage to Mr. Duterte is advanced. And this linkage rests entirely on voice recognition by an individual who claims to have overheard a telephone conversation and recognized the president's voice while being physically moved from one location to another. The alleged recipient of the telephone call himself was never interviewed, and another person present on whom the prosecution relies for corroboration
긴급 SOS입니다. 제발 우리 공장 좀 도와주세요.
did not hear the conversation. After all,
Okay, mga kapatid ko. So, hanggang dyan lang tayo po. Okay. Alright, mga kapatid ko, nakikita natin dito na grabe ang pagdepensa ni Attorney Kaufman dito sa kaso ni Pangulong Duterte. Okay? So, nakikita naman natin na hindi biro ang pagdepensa ni Attorney Kaufman. At kung hindi lang bias itong ICC sa mga desisyon nila, itong 3 judges na dito sa ating harapan, ay talagang mananalo si Pangulong Duterte sa kaso. Pero kung bias sila kasi binayaran sila, wala tayong magagawa. Wala tayong magagawa kundi magpatuloy ang kaso. Ibig kong sabihin, mga kapatid ko, itong judges at sa prosecution, gusto nilang madiin at maipatuloy ang hearing ni Pangulong Rodrigo Roa Duterte. Kaya, tingnan natin, kasi kahit papaano, mayroon man tayong lawyer
The
na
International
nagprotekta
Criminal
sa
Court
kanya.
is now in session.
Okay?
Open to interpretation.
Okay. This is open for interpretation for day 4 na tayo, mga kapatid ko. Okay, ito ang pakinggan pa rin natin ito. Na in this context, in this case, ito ang mga prosecutor sila. Ang judges natin itong 3. So, itong prosecutor, tingnan natin kung anong reaction nila dito sa presentation ni Attorney Kaufman. Okay, tuloy tayo, mga kapatid.
He spoke at length in the beginning about Article 7.1 and are an alleged problem or inconsistency with the all history case in our definition of the civilian population in this case. The law is very clear. All that Article 7.1 requires is that an attack is directed against any civilian population. That term, any civilian population in 7.1, is not limited to populations defined by nationality, ethnicity, or another distinguishing feature of that nature. It's a question of fact to be decided by the trial chamber. We have set this out, paragraphs 17 through 20 of our DCC. It is not particularly complicated. It is not blurry or ambiguous. We stated that alleged criminals in the Philippines are the civilian population, which are the object of the attack. That's a factual issue. So the position taken in the L history case
잭시오만의 비거리와 타고움,
which is different, obviously completely, factually to this case, is irrelevant. Second, the issue in L history did not concern the definition of the civilian population. It was about the nexus requirement, under Article 7, and whether it is necessary for victims of the underlying acts or crimes against humanity themselves to be members of the population. It was a different issue completely. And we have defined the population in this case. That just reminds me of what he said today at one point. Oh, well, these victims weren't necessarily related to drugs or the war on drugs. Read our brief. Read the DCC. It makes it clear that it's criminals, including drug dealers, drug pushers, drug users. The incident I went through, incident 3, in my presentation on Monday, I made it clear the victims there in Davao were alleged thieves. That is why they were murdered by Mr. Duterte.
Good.
Very quickly, he complained or spoke about well, no, I'm going to skip that, Your Honor. It's not important. Moving on, he also made yesterday multiple comments that were inaccurate about the common plan alleged in the case. First, he said there was no direct evidence that even two of the co-perpetrators met in person to discuss the plan, the common plan. Legally, there's no requirement that they do so. However, factually, what he stated was incorrect. We have brought evidence of such meetings, and they're in our pre-confirmation brief. I won't go through it, but if you look at paragraph 27 and the items cited in footnote 135 of that paragraph, it sets it out. I'll come back now to the meaning of the term neutralize in the context of this case. It's open to interpretation in the abstract, but my friend, in trying to persuade Your Honors to take the view that neutralize didn't mean anything nefarious, quoted a statement from Chief Ronald Bato de la Rosa, co-perpetrator de la Rosa, that neutralize did not mean to kill. That was at T006, page 31, lines 2 to 11. So he's been criticizing the credibility of our witnesses. Cites the police chief to say, the police chief who signed CMC 16, to say that neutralize is a neutral term that shouldn't be taken as showing any criminal intent. But we set out in our brief multiple witnesses for the mayoral period and for the presidential period who will testify that to neutralize means to kill. That's again set out in the brief, paragraphs 6 and 24. I'll read out just one example. This is ERN PHL OTP 000-15390-R01 at 0011, lines 345 to 346. Question of this insider witness. Okay, and the words eliminate and neutralize, what do they mean? Witness's answer, kill. You have to kill, whether it is a legitimate operation or not a police operation. So all of the dancing around about the term neutralize doesn't rise to the level where we would not be meeting our standard for confirmation today. One more example, my friend talked about it today. This is incident 13, in which the murder victims were Mayor Espinosa and Raul Yap. As we showed on Tuesday, Mr. Duterte, I won't play the video again, identified Espinosa as involved in drugs and said that he should be shot on sight and tracked down like a dog. And Mr. Kaufman said, yes, but Mr. Espinosa surrendered. And then tried to portray the murder of Espinosa in a jail cell as legitimate self-defense. In a jail cell, there's a shootout. The telling point here, as we said on Tuesday, transcript 5, page 10, lines 9 to 10, in the PRRD list, it was brought up, I believe, in the presentation. These two victims of incident 13, they are noted as neutralized on the list, not on the day they are arrested, not on the day they go to jail. They're marked neutralized on the days they're killed. So they were neutralized at the time they were murdered, per Mr. Duterte's government at that time. As I said in my submissions on Monday, right from the beginning, we acknowledge throughout his speeches, Mr. Duterte and some of his co-perpetrators, I used the term allies on Monday, referred to shoot to kill and self-defense, and that they sprinkled in these references to due process and legality. The evidence shows, as I said, that was only to build a veneer of legality, to create an impression of legality, and to give his lawyers something to say when this day came. And that's exactly what has happened. Mr. Kaufman has gone through, repeated these, when he can, as some kind of mantra that supposedly exculpates his client. It does not. As I said, this is the lawyer, Duterte, trying to build in a defense in case he was ever held to account for his crimes. The facts can't be denied by these sprinklings. He ran a death squad in Davao that he created. He ran it for over 20 years before he became president. His promise was to kill thousands, and he did. So it doesn't matter how many times he tried to throw in a caveat. And again, as I said, this is not uncommon in crimes committed by powerful figures. They try to build in a defense. One point Mr. Kaufman made yesterday, again, showing why this case is ready to go to trial and should not be dismissed. He refers to witnesses providing what he says is exculpatory evidence. He misstated these witnesses by saying they were OTP witnesses. They're not. We're not relying on them. but their statements are disclosed. We found these witnesses and interviewed them through the process that he portrays as somehow corrupt or biased or I don't know what. They provided exculpatory information, and we disclosed it. And that is somehow meant to say that this case should not go to confirmation? I mean, these witnesses are interviewed under 55-2. They're as suspects. Is it really unusual that when you're interviewing somebody who was involved in the crimes, that they say, I didn't do it? Does that mean that this case should not go to trial? Again, we go to trial. He can call those witnesses. The trial judges will listen to his witnesses, listen to the OTP witnesses, and then decide if we've proven our case beyond reasonable doubt or not. I'll speed up a bit, Your Honors, because I don't want to go over my time. He made a small point I just have to respond to, making a call. Why aren't there more investigations? Why aren't crimes being investigated now in the Philippines? Well, his client prevented all that by withdrawing the Philippines from the Rome Statute when he thought he might be prosecuted, thereby ensuring that we would not have jurisdiction after a certain period. Another point. My friend is trying to kind of have it both ways on how Your Honor should treat Mr. Duterte's utterances, his speeches, his words. On day 1, T0004 at page 30,
완전히 새로워진 크롬 투어를 당신이 선택해야 하는 이유.
lines 18 to 19, my friend said, Duterte's word was his word and the people knew it, end quote. Yesterday, worried about his client's confessions, that's what they are, he said, quote, this is at T0006, page 7, lines 5 to 7, he said, quote, one cannot rely on anything coming out of Mr. Duterte's mouth. All right, that's good to know if he ever decides to testify, and for his representations on interim release, that you can't trust a word that comes out of his mouth. But beyond that, as I went through on Monday, 3 times under oath, Mr. Duterte said in committee hearings, I have a death squad. Is Mr. Kaufman saying that his client is a liar and a perjurer who has no problem lying under oath? Limited use statements. I won't go through all the, frankly, nonsense that we heard about limited use statements. What I want to make clear, he tried to create an impression which is just not true. Not one witness has been granted immunity in this case. None. There is no such thing as virtual immunity or whatever he called it. He said something similar today. It's standard practice to use these statements when interviewing suspects under 55-2 who have rights, and they do not grant immunity. It just means a statement can't be used against that particular witness. And if they lie during those statements to us, to the OTP, then the agreement is void and they can be prosecuted. And his suggestion somehow that we should not interview the direct killers, Mr. Duterte's killers at the bottom of the pyramid, they shouldn't be interviewed, that's clinically insane from a prosecution point of view. And of course, some of those persons will get limited use statements if their lawyers request them. And finally, we're here in this court to prosecute the most responsible, and the most responsible is his client, former President Duterte, not the people on the ground who committed the killings. They are responsible, but they are not the most responsible. And unlike his client, the ones who have come forward have shown remorse for what they have done. His client, contrary to everything he said in the last few days, the last 3.5 hours, repeatedly admitted committing the crimes we're here for, his killings of his own people, the Filipino people, We saw some of those in our presentations. I'm sorry, I missed one point. He said there was no linkage of the incidents to Mr. Duterte. He said, my friend, not one incident where the direct order came from Mr. Duterte for one of these incidents. Well, he should look at incident 1 of the ones we have charged. And I'm afraid I don't have my cite because I skipped around. But in that incident, the evidence shows that we have a witness who heard Mr. Duterte on the phone, who heard that the order came from Superman, his client's code name and nickname. Mr. Jeremy is helping me. It's at para 89 of our brief, Your Honors. So that was wrong. That is, I just wanted to reply. He said that several times. It's not true. Back to Mr. Duterte. He's proud of his killings. He wants to be remembered for them. Decades of murdering his own people, murdering the children of the Philippines. And he claims that he did it all for his country. He doesn't deny it. He says, as I said early on, it's a necessary evil. It's for the greater good. Doesn't matter how many kids I have to kill. I'll clean up the Philippines. Now I want to play a clip, Your Honors, if we can do that, James. This is, you'll see the beginning. I played just a few seconds of it.
Okay mga kapatid ko, hanggang dito na lang po tayo. Wala na tayong masyadong oras. Malayo na ang oras natin. Okay. So, magbabalik lang tayo dito. Itutuloy lang natin ito. Maraming salamat po. God bless you po. Tita, Ma'am Alma, God bless you too. Salamat po.